All right, what's going on, everyone? So tonight I'm gonna continue diving through Marbury versus Madison. And before I get moving into this, I do want to give a shout out to Dave Jose for, you know, really for everything that he's teaching and help people understand about the fundamentals. Because if it wouldn't have been for him and me following his teachings, I would have never realized the gold that is in this case, and I would have never been really pushed into learning the fundamentals and how crucial it is for, we the people to actually go through and start comprehending the fundamentals so that we can actually hold our public servants accountable and that we can actually restore our republics. So, with that being said, I'm going to start diving into this. This is going to be another huge section out of the case that once you comprehend what this is really telling you, this is going to be something that everyone's going to be able to use. So this first section reads, "From these and many other selections which might be made, it is apparent that the framers of the Constitution contemplated that instrument as a rule for government of courts, as well as of the legislature. Why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in a special manner to their conduct and their official character. How immoral to impose it on them if they were to be used as the instruments and the knowing instruments for violating what they swore to support. The oath of office, too, imposed by the legislature is completely demonstrative of the legislative opinion on the subject. It is in these words, 'I do solemnly swear that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge all the duties incumbent on me as according to the best of my abilities and understanding, agreeably to the Constitution and the laws of the United States.' Why does a judge swear to discharge his duties agreeably to the Constitution of the United States if that Constitution forms no rule for his government, if it is closed upon him and cannot be inspected by him? If such be the real state of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. It is also not entirely unworthy of the observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution that have rank. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. The rule must be discharged." All right, now let's break this down. So why otherwise does it direct the judges to take an oath to support it? So Justice Marshall, he's exposing the core truth that the administrative state does not want any of us to know, right? Does not want we the people to understand this. If the Constitution did not govern judges, all our public servants, there would be no rational or moral reason to force them to swear an oath to obey it. This sentence is one of the most destructive weapons against judicial corruption. These administrative courts, the family courts, traffic courts, CPS courts, and every single one of these tribunals pretending to be law. Now, what Marshall's actually saying, right, that the Constitution binds the judges, our public servants, not we the people. The judges swear an oath, our legislature swear an oath, the executive swear an oath. We the people, we do not swear an oath to any government. We created the constitutions, which created the government, which our public servants willingly agreed to be governed by, right? So we the masters, we don't swear to the servant. The beneficiary never swears to the trustee. This is why the framers made judges swear a constitutional oath. They are the trustees and our servants, and we're the sovereigns. So if judges were free to ignore the Constitution, the oath would just be a fraud, right? So Marshall calls it worse than solemn mockery. So what in modern terms does this mean? It would be criminal. It's a criminal impersonation of authority, because a judge who violates the Constitution, his oath, violates the very condition of his office, which leaves them personally liable. Okay? The oath proves judges must apply the Constitution before statutes, policies, or agency rules. So Marshall is saying the oath is a binding contract. The Constitution is the rule book, the laws that our public servants are bound by, okay? And any judge or public servant acting outside the rule book they willingly agree to be governed by is a lawless actor that can be personally held responsible. Now I'm going to go through and show you a bunch of law maxims that actually back this up even further. Now, here's a few out of Charles Wiseman's selections of law maxims, okay? Now, these are universally accepted. These are proven, and you can go through this, you can pull up this PDF and go find all the law maxims and dig into them in the cases where they were settled, okay? So we have 63Z. A judge who exceeds his office or jurisdiction is not to be obeyed. So this law maxim destroys unlawful orders, administrative rulings, invalid contempt threats, and unconstitutional mandates. So if a judge violates due process of law, separation of powers, constitutional protected rights, their oath of office, then that judge is outside of jurisdiction and their orders are void, not voidable. Void means it has no lawful effect, okay? It doesn't have to be proven voidable down the road. It has no lawful effect from its inception. Now, 64A, a judgment given by one who is not the proper judge is of no force. So for example, family court judges acting under CPS mandates, court rules, executive branch guidelines, policies not made in pursuance to the Constitution, right? They're not proper judges because they're not applying constitutional law. So their judgments lawfully void, okay? Means zero lawful effect. We also have 94A, where there's a legal right, there's also a legal remedy. This maxim destroys courts that doesn't handle constitutional issues. They tell you must follow our administrative procedure first, or they tell you we don't recognize your jurisdictional challenge. If you have a right, the court must provide a remedy. If they deny remedy, they violate their oath. Leaves them personally liable. We have 51O, all political powers inherent in the people. This appears almost in every single state constitution, right? Michigan, Arizona, Georgia, Kentucky, New Hampshire, Wisconsin, and so forth, right? So this means the judge has no power except it was expressly delegated to them under the rules they willingly agree to be governed by. If they exceed that delegation, their act is void. Not voidable, it is void from inception. We have 51P. The main object of government is the protection of personal rights. If government destroys or infringes rights, right, like they do family court, CPS court, traffic court, right, they're operating outside, it is operating outside of its lawful object, which means it's outside of its jurisdiction. We also have 65U, Constitution and laws precede the judiciary. The judge is not the source of law, the judge is controlled by law. This is the exact opposite of what this modern day administrative system is doing, violating separation of powers. Now I also have some state constitution provisions we're going to hit. We have Kentucky Constitution Article 2, or Section 26, which tells you all laws contrary to the Bill of Rights is void. So this is one of the strongest voiding clauses in any state constitution, because if a judge, CPS worker, prosecutor, police officer enforces something contrary to the Bill of Rights, their act is void and unlawful and leaves them personally liable. Now we have Georgia Constitution, Article 1, Section 2, Paragraph 1, which tells you public officers are the trustees and servants of the people and are at all times amenable to us. So our trustee, our servant, cannot override the trust, they can't violate the trust, they can't expand the trust, they can't alter the trust. The Constitution is the trust indenture. Our public servants are trustees that are bound by these contracts, and we, the people, are the beneficiary of these contracts. So any trustee who violates the trust loses all lawful authority and all lawful immunity. Now we have Michigan's preamble. We the people, grateful to Almighty God, ordained and established this Constitution. This proves we the people created the constitutions. Judges did not create it. The legislatures did not create it. Agencies did not create it. Thus, we the people are superior to every single public officer in public office. Michigan Constitution, Article 1, Section 1, all political powers inherent in the people. This is identical to Arizona's and echoes Georgia's and New Hampshire's and several others. This destroys any claim that a judge has inherent authority. They only have the limited delegated powers that we granted to them, and only within constitutional limits. Now we also have Norton versus Shelby County. An unconstitutional act is not law, it imposes no duties, it confers no rights, it is as though it never existed. This is a nuclear bomb. Combine this with Marbury, so if a judge enforces an unconstitutional act, he is enforcing nothing and violating the Constitution, which triggers the maximums, right? No judge acting outside of his jurisdiction is to be obeyed. A judgment by one who is not a proper judge is void. So now you see this is irrefutable in any court. A constitution governs the judges and our public servants. The judge swears our public servants swear an oath to obey it. If the judge violates it, he leaves jurisdiction. All orders outside jurisdiction are void. Unconstitutional statutes are not laws and cannot be enforced. Public officials are our trustees and our servants, not rulers. The people are the source of all political power. Our rights come first. Government power comes second, and we control everything, and this is exactly the type of material we need to restore our republics.